Hello and welcome to Organized, the Business Law Breakdown. I'm Professor Seth C. Orenberg, and today we're exploring the entity theory of partnerships. One of the most significant developments in modern partnership law is the recognition of partnerships as distinct legal entities. Historically, partnerships were viewed as aggregates of their individual partners, as opposed to something separate. But this approach created confusion and inefficiencies. The entity theory, which is codified in the Revised Uniform Partnership Act, simplifies many aspects of partnership and provides stability for third parties dealing with partnerships by treating partnerships as their own thing, as their own entity. So in this lecture, we'll discuss the evolution of the entity theory. We'll talk about its practical implications, and we'll look at the few exceptions where the aggregate view still persists. Under the traditional aggregate theory, a partnership was not considered a separate legal entity. Instead, it was merely a collection of its individual partners. This meant the partnership could not itself own property or enter contracts or sue or be sued, not in its own name because it wasn't a thing unto itself. Every action had to be taken by the partners collectively. And this complicated transactions and created legal uncertainties for those dealing with partnerships, because if one partner left the partnership, did that dissolve the aggregate? Who was responsible for the ensuing or previous debts and obligations? So modern partnership law moved away from this old aggregate theory in favor of the new entity theory of partnership. And you can find this codified in the Revised Uniform Partnership Act, Section 201, which explicitly states that a partnership is an entity distinct from its partners. This recognition simplifies a partnership's legal identity and aligns it with other business structures, such as corporations and limited liability companies, which have been recognized as separate entities. Under the entity theory, the partnership itself can own property, the partnership can enter contracts, and the partnership can sue or be sued in its own name. This provides greater clarity and efficiency in legal and business dealings. The entity theory has several practical implications that benefit both partnerships and third parties. First, it allows partnerships to own property in its own name, so a partnership can operate more efficiently in many cases. A partnership operating a real estate business can hold title to property under the partnership's name, instead of this property being owned in the individual names of the partners. And this avoids complications when partners enter or leave the partnership. It basically ensures continuity in property ownership. Second, the entity theory streamlines legal process because it allows the partnership to sue or be sued as a single entity. So if a third party has a claim against the partnership, they can sue the partnership, as opposed to having to sue each individual partner as a defendant. And similarly, the partnership can initiate legal action in its own name to enforce its partnership rights. This approach reduces procedural hurdles, and it tends to promote fairness for the partnership and for its creditors. Third, the entity theory facilitates the separation of personal and partnership liability. Under the Revised Uniform Partnership Act, Section 306, while partners remain jointly and severably liable for the obligations of the partnership, creditors must first exhaust the partnership's assets before they can pursue the personal assets of the partners. This adds a layer of protection for partners and provides a clear order of priority for creditors. Although the entity theory is the dominant framework, there are exceptions where the aggregate view still applies. For example, there are still states that have not adopted the Revised Uniform Partnership Act. And under the Uniform Partnership Act of 1914, the older statute, the aggregate theory might be applied by courts. Also, under tax law, the tax treatment of partnership retains the elements of the aggregate theory. Partnerships are treated as what we call pass-through entities for tax purposes. So it's kind of a combination of the entity theory and the aggregate theory. The entity is not really perceived by the tax authorities. What this means in practice is the profits and losses of the partnership are reported on individual tax returns of the partners, rather than being taxed at the partnership level. If you've ever heard about getting K1'd or getting a K1, this means being issued a separate tax return for your partnership profits and losses. This preserves the flexibility and simplicity that partnerships offer compared to corporations, while still preserving some of the aspects that make them distinct. Another area where the aggregate theory lingers is in the dissolution of partnerships, which we'll talk about later in this season. When a partnership dissolves, the entity effectively ceases to exist, and the remaining partners are responsible for winding up the affairs. The process underscores the continuing importance of the partner's collective role in the partnership's existence. So we see that the entity theory strikes a balance between the stability needed for external dealings and the flexibility that partnerships provide internally. By treating the partnership as a distinct entity, the law ensures that third parties can rely on the partnership's identity, and its assets can be separate and not intermingled in the personal affairs of the partners. At the same time, the retained elements of the older aggregate theory preserve the informal and collaborative nature of partnerships and some of their tax advantages, or at least tax uniqueness, making them attractive to small business and entrepreneurial ventures and for organizations that need that particular flow-through tax structure. In conclusion, the entity theory of partnerships represents a critical evolution in partnership law. It provides clarity and stability for both partnerships and the parties they deal with. By allowing partnerships to operate as distinct legal entities, the law facilitates smoother transactions. It provides clearer accountability, and it offers enhanced protections for partners and third parties alike. So as you might reflect on today's lecture, you can consider how the entity theory aligns with your expectations. When you see a partnership listed, do you perceive that as something independent, or do you perceive that as a group of people? Also, how does the entity theory align with the needs of modern businesses? What are situations where the aggregate theory might still serve a purpose? What are some business relationships where you might want to be perceived and act as a group of people and not as a separate entity? Thank you for joining me on today's lecture. I'm Professor Seth C. Orenberg, and this was Organized, the Business Law Breakdown. In our next lecture, we dive into fiduciary duties and partnerships. I'll talk to you then.